Good morning, everyone. Welcome. This is Ramolady from Ramolady Reports, and I'm here this morning just to do a very brief update on Todd Giffen. Long overdue. Now, I've been intending to do this update for quite a while, and all sorts of things have been intervening, and then the holidays and everything that transpired over the holidays, and Linda Thayer's case as well, which has taken up a lot of attention. And I am indeed juggling various projects, both video projects as well as the article writing. So I apologize to people who've been asking about what's going on with Todd and not getting much of an answer from me except emails. Um, so Todd has been keeping in touch via email with me and with various other people, and he has recently sent out a couple emails to ask to make a request that other people who are interested in his welfare get in touch with him, communicate with him, and stay on top of what is going on. So, I wanted to share a few bits of information as to how you can do that. His latest email was to me yesterday. He wanted me to get him a big email list. Now, I'm not entirely certain which big email list would encompass the people who really wish to keep in touch and give Todd support and advice. So, what I'm going to ask today is if you'd like to keep in touch with Todd on a list, on an email list, that I'm also on, just send me your email and I'll create a list. That's one thing. And then the other thing you can do is simply write to him yourself. And his email, which I'm going to put below this video, is, he's communicating from this, I guess it's a prison. It's actually like a psych institution, I gather, but it's also a prison. So it's tgiffen1424 at emailinterface.org. And that's TGIFFEN 1424 at emailinterface, all one word, .org. But I will also post this email below this video. Now, so that's one way he asks that you keep in touch with him. If you wish to keep in touch by text, I guess that's SMS, you can use this email address, I suppose, but also use this code, which is 5412486919. I'll repeat that. It's 5412486919. And, I'll stick it below the video as well. So the basic info he wanted me to convey with this latest request, I guess, for communication is please let people know that he's got a new private investigator and he's got a new lawyer. Now, I gather the lawyer is, yet another one of those public defenders that the court system hands to people and who apparently don't do a very good job of defending anybody because, in Todd's case, certainly, these public defenders have been kind of recycled. Every few months, they completely fail Todd, they get thrown out, and somebody else gets on board and engages in similar infamy. So, the current public abandoner or defender, whichever you may wish to call him, is Anthony Schwartz of Portland, Oregon. And he has an email address, which I will put below the video. And his private investigator, who is somebody he trusts greatly and who I'm very glad he was able to, I guess, persuade Jennifer Maganey to come on board as his private investigator. Because she's been in contact with us, and I'm glad that that has worked out. So I will place her email as well below. So if people wish to call them or write them. He says they both have phones. Hallelujah. Uh, but he doesn't give the phone numbers. In any case, I guess you can find that online. He's got an appeal lawyer, And that's Bear Wilner Nugent, bwnlaw@gmail.com. I will post that as well. And they have phones too. So I guess they're in the 21st century with us. But I'm not entirely certain what he expects people to call them for. But if you wish to put them on an email list just to present information on your testimonial for Todd or your support of him, that might be a good thing to do. As with everything, when writing to to anybody who is engaged in public office, it's always best to, employ basic business rules of communication, CYA, be polite, etc., and nothing more. Because, as many people know, and this is the background to Todd's case, really, how Todd ended up in prison in the first place was he sent emails to Senator Ron Wyden and to another state representative in Oregon. And he had been communicating with them for a very long time. He had been reporting the kind of abuse he'd been getting at the hands of locals, at the hands of police, and he had been reporting assault and victimization and persecution with directed energy weapons and neurotechnology, which is not new. People around the world and around the country, and definitely many in Oregon, are reporting the very same. But as we know, these assaults with non lethal anti personnel, directed energy weaponry, and neurotechnology continue to be denied by the very people who are using and employing them, and continue to form the basis for people being kind of consigned to the lines, and in other words, the mental health system. So psychiatry is waiting with its maw open on the side, and the courts and the police send people straight to psychiatry when mention of directed energy weapons is made or neurotechnology, assault and experimentation is made mention of. So that unfortunately is what happened to Todd, because he wrote these emails, and I guess, he'd been doing it for a long time. He didn't get any help, obviously, from the senators and representatives. I think at this point in time, we've all gotten used to getting no help from them. So, however, after he went through a period of time in treating them, the tone of his emails kind of escalated in complaint, and he started to use language that many could read as being directly offensive. As a consequence of this, those two senators um, got the U.S. Capitol Police and the FBI involved, and Todd was arrested when he was getting ready to join the Million Man March, I believe is what it was, in November 2018. 6th November 2018, he was arrested. He wasn't given a hearing immediately. He wasn't given bail. All sorts of miscarriages of justice attended his incarceration. And when he was eventually given a hearing, it turned out to be a commitment hearing. And there was a court appointed psychiatrist who declared him incompetent. This was challenged, and there was, I believe, a second hearing. This was the one at which Dr. Seth Farber was present. No one else was called. I was also supposed to be called, but I was not called. Again, many anomalies, aberrations, all sorts of strange droppings off and abandonments, presided over by the chief abandoner, the public defender, to whom many of us wrote, all to no avail. And the outcome of that particular hearing was that he was indeed committed or um, decreed or ordered to go spend some time, 4 months, I guess, is their general procedure, at this mental health institution in Butte, South Carolina, or North Carolina, I forget. And presumably the intention was to dose him up with drugs and then bring him back to court, call him competent, which is what they do, which is what this completely bogus system of psychiatry and court incompetence engages in. Bring him back, say he's competent now, and then impose a sentence. That's what they do. So that has not happened as yet. So apparently, Todd has been stuck in this place, this psych institution, for about 6 months now. He, I understand, is refusing any medical treatment from the staff. So, what I'm going to do is I'm actually going to talk a little bit about that because there was an issue regarding his medical records. And he sent an email. Now, he's been copying me, I guess, on some of his emails, and then he's been sending me direct emails. But other people may also be getting the same emails. In any case, it kind of sounds like the public defender certainly got access to his medical records, and Todd disputes that the medical records can even be made available to somebody without a special kind of request of some kind. So I'll just read a few paragraphs of what he says over here in this email. He has quoted a case called the Kitzhaber case. And he says it specifically covers whether a judge can order the release of medical records from a hospital. Under Kitzhaber and several cases mentioned inside it, medical records and emails are Fourth Amendment protected, thus the government is not allowed to obtain them even for medical reasons. As you allege they can, I guess this is, he's addressing his new public defender. Because the amendment bans a judge from issuing a warrant to seize the records, and a subpoena cannot be used either, because the Fourth Amendment governs the subpoena. And judges and government are bound by the Fourth Amendment in all cases where they seek to get access to anything, emails, medical records, etc. There is no exception to the Fourth Amendment just because the judge wants to restore my competency and seek accurate diagnosis. So you conspired with the judge and prosecutor and Dr. Cochrane from Butner to illegally obtain my records in violation of the Fourth Amendment. So you see, this is the current dispute that's ongoing. He feels that the medical staff at Butner and the judge, the prosecutor, and the public defender have all engaged in malpractice. Also, I'm refusing all medical care and treatment from Butner staff. That's why I'm not disclosing any records from them. And the government cannot forcibly obtain my medical records, as Kitzhaber points out. Force is only allowed under the rules of the Fourth Amendment, and Rule 41C thus applies. It doesn't matter if the records are being used for prosecution or not, because as Kitzhaber points out, citizens have a Fourth Amendment right to privacy, thus the government is not allowed to search or seize the documents. So Butner does not have a right to medical records if the Fourth Amendment doesn't allow it. The judge's order is entirely illegal, and you knew it. So he's kind of calling his new lawyer or attorney, public defender attorney, out and demanding that medical records are kept private. So he's got a few quotes from that case. It's Grand Jury Subpoena versus Kitzhaber 828 F3D 1083. Emails also contain content. This is a quote from that case, and I'll just read this before I move on. Emails also contain content that the sender presumes will be read only by the intended recipient. The court has also noted that electronic storage devices such as laptops contain the most intimate details of our lives, financial records, confidential business documents, medical records, and private emails, and held that these records are expected to be kept private, and this expectation is one that society is prepared to recognize as reasonable. The U.S. Supreme Court, now this is outside that court, I guess, he's including something else. The U.S. Supreme Court, too, has emphasized recently the ability of digital troves to contain the sum of an individual's private life. U.S. versus Cotterman, 704 F3D 952. And he's got some other quotes. And a person does not forfeit his expectation of privacy merely because a private container is located in a place that is not controlled exclusively by the container's owner. That's US versus Mongur F8 588 F3D 975. Waller versus US 477 US 649. So he says he sent all this case law and details to Anthony Schwartz back on December 3rd. He went into court and didn't bring any of this up because he intended to help the government abuse me and falsely imprison me. So, well, what's going on obviously over here is that there is a huge cover up. There's many cover ups going on. The word conspiracy is not to be taken lightly in this case. It appears that certain people are conspiring with each other. Certain things are being hidden because when you speak about neurotechnology and you speak about neurotechnology experimentation, you are speaking essentially of what the government wishes to keep classified. Many people know that these experiments are going on, these highly unethical experiments are going on. They involve torture, they involve extreme invasions of bodily privacy and brain privacy and integrity. And they're not being disclosed to the public, they're not being disclosed to the medical profession and or to the legal profession for that matter. But there is, it appears to be, and certainly from following this case and reporting on it for a while, there do appear to be parties in the legal profession within the court system who are actively collaborating and colluding and permitting this mayhem to continue. Essentially, these are activities that have been classified to conceal crime. That's what they are. These are just as bad as the MK Ultra experiments we learned about from the 70s, if not worse. They've had 20 to 30 years to fine tune and make sophisticated their use and abuse of people's brains and bodies. And that indeed is what is being reported today from many people. So, when Todd makes statements that people are conspiring, they are not idle statements and they are not delusional statements. They have basis in fact, they have basis in evidence, they have basis in mass consensus of reportage as well. So it's a tragic because he's reporting abuse across a very long time period. And now he's sitting in jail, being kept in jail very unjustly and wrongfully. And it doesn't look like anyone's letting him out anytime soon. And you have to know one of the reasons Todd Giffen has been targeted for incarceration, it appears, in addition to everything else. He's very smart. He does a lot of research, and he's had a lot of information up on his websites, obamasweapon.com, oregonstatehospital.net, etc. And he's after the Project Stargate archives were released by the CIA on their website, he did a lot of digging into them and uncovered a lot of information. So, what he calls synthetic telepathy or remote neural monitoring is NSA ESP. And certainly, if you go into those NSA ESP documents, the remote viewing documents, you see a lot of commonalities between that and what is termed as synthetic telepathy by people like Richard Allen Miller, who says that he helped develop it. So, reading his emails, it's really tragic, the whole story, because he talks about so much about his case. Now, I can read a little bit about what happened to him at Oregon State Hospital, OSH. And he says, my knowledge for why the government wanted the records, um, and this is the medical records again that he's talking about over here, is being protected by the Fourth Amendment. Is they know their friends at OSH abused me heavily in OSH. Dr. Purnasidatta, PhD, QME, my personal doctor, said the OSH doctors took part in trying to murder me and wanted me dead. And he personally saw many patients murdered and abused, even raped by dangerous state employees. Details about this is not kept in the medical records, investigated or dealt with normally. Very few staff are even willing to talk. The government knows this and wants the records purely to build their fake case against against me, knowing it would not contain the truth. Security video audio of the staff beating me up on camera or admitting to being caught doing crime against me. Dr. Cochran, and this is his doctor in Butner right now, and the prosecutor already knew this about the records. They also knew all classified info is kept out of the records. That is the exact same behavior we saw in Barrett versus US 660 F SUPP 1291 and Barrett versus US 646F, I guess the SUPP is supplement 1345. Note, I have a dozen case laws where this has been caught happening before. They did the same thing to inmates in MK Ultra with over 100,000 plus victims. Their abuse hidden from their records, or the government covered their involvement up, shredded documents, protected the staff's involvement by shielding their identities. See CIA versus Sims 471 US 159. These blank blank running our government today have the same capability in place. It's got more funding than ever before. It's more sophisticated than ever, and they're targeting me with it. The judge knows it. That's why he granted the illegal seizure of my records. He wants to bake a fake public narrative without the truth in it, blocking all third party witnesses, data, and things like security video and audio, which has been recording their abuses in and out of custody. He doesn't want the video or audio shown, which will show their staff committing crimes against me. Anthony Schwartz knows this and is taking part obstructing justice under 42 U.S.C. 1985 and other statutes. So, this is a little bit of information about the medical records and about government conspiracies to hide classified info, to seize audio video records, and to literally withhold evidence. And there's one more email that talks about classified information, and I'm going to read a little bit of that. He mentions SIPA, which I guess is the Classified Information Protection Act. So I'll read a little bit about this from this email. So the last messages I sent about SIPA FISA, that's the FISA that we know about, FISA, are true. But here's the other part about SIPA. They claim that SIPA is to give me access to classified information. It's not merely to protect and cover it all up. I disagree, however, with that. I believe SIPA, FISA / classified world needs a shutdown as unconstitutional because the laws, including National Security Act, SIPA, FISA, are sub-constitutional. The main constitution forbids criminal syndicates from being set up and shielded in secrecy by classification systems at the government level. Due process clause is violated by the withholding of the information from the record, and the public defendant, that is police, must lie in their complaints, criminal reports, hiding the truth of their operations and how the case developed. Citizens' rights to see all the information at a public trial, and accused rights to have all the information of a case divulged at a public trial is violated, etc. So, Todd's views are always very interesting, and one of the things I have wanted to do, I simply have not had the time, is to post some of these emails on a public page so people can read his emails as they come in. And I'll give it a shot. I'll try to do it just as soon as I get a moment to breathe. So let me read a little bit more of his email here. If governments like South Africa can operate without classified worlds, see their constitution which bans such, requiring the government to divulge all information they possess to the public, then the US can surely operate on the same level. My understanding is classification is used to create a secret society purely for the rich, to keep their technology developments, wrongdoing, human experiments, and other tactics secret, which they use to control which they use to control resources they own and protect them from the general public and other countries. It has nothing to do with fighting other countries, that is Russia or the nuclear scare, defending the country. All countries are involved in hoaxing the public to scare them into believing classification, and rules enacted by the wealthy elite must be followed and are required for security reasons. They also use this shield of lies to attack innocent citizens like me. They target with torture, human experiments, rape, directed energy, mind reading, cover ups, etc. The public, when they are told about cases like mine, are told by the classified government I'm not a victim, I'm a schizophrenic, to dissuade the public from believing me and covering up my abuse in the public record. This is the tactic Congress has chosen to utilize. This is the tactic businesses have chosen to utilize. In the public realm, people are told fake stories about security, crimes, and business as why the abuses are done to them and the public. But to truly understand why the abuse is being done, they need the classified information. So, thus, our trials must be truly public. The classified information must be told to juries, made available to media, and given to the public who go to court and watch the proceedings. The info must be put on the internet for all eyes and ears to see and hear. See Waller versus Georgia 467, US 39, SCOTUS, already ruled. That's the Supreme Court of the United States. Already ruled the trials and proceedings must be public even when secret police wiretaps are being discussed. In Waller versus Georgia, the court closed the proceeding to the public because secret wiretaps were being discussed at a suppression hearing. SCOTUS rules the closing illegal. So, this behavior of closing the court to the public by only letting the judges, police, undercovers, etc., and attorneys know the classified information must end. Secret trials where only fake substitute information or nothing at all is given to the public must end. This is not desired to those in power because a backlash and organization of political overthrow will be possible. They are trying to control mental and emotional reactions in the public by hiding this information, nothing more. They want us to live like babies whose minds never develop. They want us to be controllable like puppy dogs who only know domestication. It's time for the human race to be free. And he's got, well, this is a long email. So let me read a little bit more. Although SIPA, FISA, NSA is a fraud, SIPA, the Classified Information Protection Act, technically says in it, I have the power to have classified info access by forcing the government to create a substitution statement that must confirm, yes, I am a mind control victim. Yes, I know classified info. Yes, I'm in a classified government program. Yes, I'm a victim of parakinesis. Yes, I'm a remote view ESP victim. Yes, my lawyers are double agents who received classified intel about my case and sought to sabotage me and let me know on the sly while they abused me to my face. He's actually made this accusation of his lawyers being double agents before, and if you go onto my website, everydayconcern.net, actually, and go through some of the articles, you will be able to trace that entire procedure by which many of us came to the same conclusion. And I think he meant two of his lawyers, previous public defenders, Todd Bofferding and Lisa Ludwig, whom both of whom I contacted and tried to speak to. I emailed both. Todd Buffeting, I think, was playing phone tag with me for a while. I never did speak to him directly. Lisa Ludwig just stopped corresponding to all of us, and in fact, apparently told Todd that she had no interest in corresponding with any of us. Um, Concerned supporters of Todd Giffen, who actually have known him and could speak for him. Yes, so to return to that, yes, the government has access to everyone's brains and thoughts through satellite, radar, interferometry scans. Yes, the government can. This is not anymore a story. Just go to James Giordano's many lectures and you will hear the same confession that yes, the government is currently reading brains and scanning minds, or the other way around. Yes, the government can go into citizens' dreams, memories, visual auditory systems with directed energy from these platforms and alter biological functions, including programming in false memories and dreams. Yes, the government can do all the abuses listed in the Robert Duncan ABSM MBA PhD, the executive summary, neuropsychological and electronic no touch torture report, and the techniques we used on Todd. Yes, we set Todd up and have him falsely imprisoned. Yes, all the jail staff, healthcare undercovers in the jails know this is true. This is another part of Todd's story where he has talked about undercovers in the prison. I've reported on it somewhat in my articles. I could report on it further. He's talked about it a lot more in his emails. And one of the people, one of the very closely associated parties in this story has also written to me. So I will cover that another day. For now, let me end with this email actually. So all the jail staff, healthcare undercovers in the jails know this is true. Yes, the FBI knows it's true. Yes, the marshals know. Yes, yes, yes. We set Todd up to look mentally ill. Yes, everything Todd reported in 618 CV01846MC is true. That's his case number, I guess. Now, he's basically saying that this is from that Classified Information Protection Act. Now, I have to go and look at that act. I haven't really had time to do that. But this is something Todd spends a lot of his time doing. He's looking at all of these acts. He's reading case law. Thankfully, he has access to, legal information, I guess, sitting in the jail, where he is doing huge amounts of research, as he always has been doing. Um, and so basically, what he's saying is that this act says that he has the power to have classified info access by forcing the government to create a substitution statement that confirms all of these things. Now, I'm not entirely sure how you force the government to do anything, let alone create a statement, but perhaps it's written into the act. That's definitely something to explore. People are welcome to go check it out. It's the Classified Information Protection Act. I'll, you know, look it up and post a couple links below. So, and he quotes another case where he says, "Read U.S. versus Set Agati 728 F3D 885, which states the government has to provide statements confirming all these things are true. Substitute statements for the actual classified info. Then, if you want the details they left out of their statements, talk to me, knowing it's all true." Or C618 CV, his case number for what they left out, want to leave out. In Sedagati, the man got a new case because the government substitution for SEPA was inadequate. Now, I could have built this case and had it to trial 10 months ago. Here's the other thing. He knows enough about his case to actually be able to build his own case himself, but, he's been stymied a great deal by his public defenders. But they wouldn't let me hire or subpoena any of my, and of course, he's got dreams of having a very large case, lots of witnesses, 150 plus witnesses, experts, and they used 4241 to stop any proceedings from occurring, used it to punish me, lock me up without trial, falsely imprisoned me using it because they knew it was vulnerable and could be used as a weapon. There's no due process or protections built into it. It lets the government insert their double agents in the middle for attacks. That is, Attorney General psychologist. He's talking about the psychologist who deemed him incompetent and gave him the very wrongful diagnosis of schizophrenia, which I understand is the most extreme diagnosis that a psychologist or psychiatrist can hand to somebody, and can only be handed to somebody based on a history of evidence to suggest the same. But I did read her report, and her report makes this conclusion without evidence. And there's nothing in his own past history to suggest it. Lets them bake false records with their attorney general psychologist police tactics, and even allows commitments of people and sending them to faraway facilities where they have no defense tools or communication tools for long periods without the normal findings of guilty or dangerousness. I gather that's what they've done in Todd's case. Won't let me speak in court or file motions, that is, have me bound and gagged, etc. If only I could be evaluated by my own doctors, they'd write reports saying I was badly hurt in custody, and all this was true, but they wouldn't allow it. Seth Farber, PhD, and others wrote the courts and said it was all true, but they blocked their communications mostly, or ignoring it because of their double agent status. They got me locked up, being tortured, just like Ziegler versus Abbasi, Padilla versus you, etc. The tactic has been exposed many times. So, that's a few of Todd's emails currently. And I just wanted to give a little bit of the gist of what is going through his mind currently and what he's working on, what he's dealing with, and the situation, because he's now been incarcerated and held in this institution for over a year. So it would have been a full year, 6th November 2018. It's close to 2 months beyond that year time period. So Todd is still being held, and again, he is reaching out to people. He's asking for people to please write to him, get in touch with him, help inform him, and help inform those who are newly working on his case. That is the new private investigator and the new attorney. So, to that extent, I hope whoever's listening, if you care about Todd, if you know him, if you've worked with him as an activist, etc., please do get in touch with him. Send me your email. I'll try to pull all the emails together in one list and send it to Todd as well. And that's about all I wanted to say this morning. I haven't had a chance to check into chat, um, but I thank everyone who's popped into chat and to say hello, and thank you for paying attention to this case. It's very important for those of us on the outside who can see this kind of injustice going on. When people are being wrongfully imprisoned, incarcerated for long periods, no real justice, obvious evidence of collusion, conspiracy, etc. It's very important for those of us who are outside to pay attention, to be aware, and to take whatever little action we can. To speak out, to register protest at this injustice, etc. Because if we don't, um, the situation, the status quo, will simply proceed mowing more and more of us down. So humanity is very much under attack, under assault. And as Todd pointed out in his letters, it's this whole classified structure, the secrecy structure, that is largely behind it. Because it permits a large portion of the population to hold down jobs, actually, to be paid for their crimes and predate on others, predate on anybody who speaks out, predate on people who help others, predate on people who are victimized by the bad apples in their own crowd, because that's what Todd has been reporting for years and years. Being victimized at a hospital, being victimized at a police station, being victimized, being persecuted and attacked by police, etc. And his is not a singular case. There are many other cases of police abuse in this country. I mean, you read about them pretty much every day. So, and there are also many cases of neurotech experimentation, assault, and victimization and exploitation. So, Todd is one among many, but because he has been arrested and is incarcerated, his case and his voice becomes doubly important. So, let's just keep the light burning, I guess, and communicate with him as much as you can and help as much as you can. So, on that note, I'll bid goodbye. Thanks everyone for watching. Have a great morning. And I'll check in again about Todd, very soon over the next few weeks. I'll post whatever info I can. Give it a few days and look for it on my website, everydayconcern.net. And anyone who wants to learn more about Todd Giffen's case, go to my website, everydayconcern.net, type in Todd Giffen in the search box, and you will find a whole load of articles. So, hope that helps. So, thanks everyone. See you again shortly. Bye bye.